So good morning, good afternoon, good evening, depending on your time zone. My name is Carter Chang, and welcome to this session, the Climate Justice Turning Point, from Advisory Opinion to Accountability, hosted by World's Youth for Climate Justice, Pacific Island Students Fighting Climate Change, and the Bangladesh Society of International Law during the 2025 UNFCCC COP30 Climate Law and Governance Day. Thank you for joining us, and I'll hand over the floor to Advocate Samira Ben Ali, Global Campaign Leads, World Youth for Climate Justice, and Advocate Fahim Abrar Abid, founder of Bangladesh Society of International Law. Over to you.
Thank you so much for having us for this event. This is one of the third time I think that we're participating in this event. And I remember back in 2023 when we were in Dubai, where we started, where we're really in the height of campaigning to get this initiative or an advisory opinion. The Climate Law and Governance Initiative was one of our biggest supporters, providing us with the Global Leadership Award and helping us go and start really move forward this campaign. So really, really grateful to be here, especially because now, since July, we have the advisory opinion and we're starting to see the effect in the negotiation rooms at COP30. As you all already know, Pacific Island Students Fighting Climate Change started in 2019 and World Youth Climate Justice started a little bit after. And our whole campaign since the beginning was to make sure that the law is clear so that states and other stakeholders that are involved in the harming the climate system cannot escape anymore in understanding what their obligations are. So that's why I really, I'm happy to be here. I'll hand it over to my colleague Fahim to take it over for the moderation.
Thank you, Samira. Thank you, Cheng, for the opportunity. Distinguished delegates, esteemed panelists, and colleagues around the world, warm greetings from Estonia. It's an honor today to join virtually at the Climate Law and Governance Day 2025, organized by the Climate Law and Governance Initiative during the UNFCCC COP30, and of course to represent my organization, the Bangladesh Society of International Law, BSIL, alongside two of my advisors here. BSIL is a young but ambitious organization committed to strengthening Bangladesh's role in global climate and human rights conversations. BSIL has been active in both research and advocacy. Since its foundations 7 months ago, we have already published a symposium in the Cambridge Journal of International Law. We signed a Springer Book contract consisting of 6 chapters on climate, and recently initiated the Bangladesh Blog of International Law, with its inaugural scholarship being dedicated a symposium on the ICJ Climate Advisory Opinion and the Bay of Bengal. So this work covers issues from state obligations to the duties of non-actors, from agriculture to salinity, and from migration to indigenous rights. So as part of our ongoing effort, we take part in this important initiative, partnering with pioneering climate justice organizations like the World's Youth for Climate Justice and the Pacific Island Students Fighting Climate Change, who have a strong voice before this International Court of Justice in the Climate Advisory Opinion. And today's legal roundtable, the Climate Justice Turning Point, from advisory opinion to accountability, is particularly important for us because while much of the world is still speaking about the future of effects of climate change, Bangladesh is already living its reality. We are already a victim. Around 2.5 million people have been displaced for climate-induced reasons, coupled with deeply concerning sea level rise. And global experts now predicted that much of the country's territory will be submerged by 2050, only 25 years from now. So for Bangladesh, climate change is not an abstract risk. It is a daily disruption of life, livelihoods, and dignity. Bangladesh is indeed one of these frontline states, but it is not alone. And that's why we need this global conversation. Against this backdrop, recent developments in international environmental law, most notably the International Court of Justice advisory opinion on the obligation of states in respect of climate change, also widely regarded as the the climate advisory opinion, are of utmost importance, and not only for us, but for the entire international community. Yet, advisory opinions do not implement themselves. Their real life their real life impact depends on how judges, lawyers, scholars, public officials, community members, civil society organizations, and movements use them in litigation, in policymaking, in classroom, in advocacy, in education, everywhere. That is why we have come together today. We have judges, we have an attorney, we have an academician, we have advocates, we have government officials, youth leaders, civil society organizations. Though above all, we are all climate activists. Together, we will reflect on how advisory opinions can be transferred into accountability, how they can shape negotiations, influence national and regional frameworks, and empower communities on the front lines. As we gather today, some in Belém, Brazil, joining, and some others joining from across the world, we are united by a shared understanding that climate justice requires strong legal foundations, informed research, and empowered voices. Advisory opinions, no matter how progressive, will remain words on paper unless we collectively give them life through advocacy, litigation, policy, and whatever way possible. So let this roundtable be a turning point where legal principles become tools for protection, where the voices of the most affected shape the rules that govern us all, and where no state, no actor can say, we did not know or we had no duty. The law is clearer than ever. The science is louder than ever. The suffering is deeper than ever. So our only legitimate response should be stronger than ever. So with that, I conclude my part, my opening speech, and I'd like to introduce our distinguished panelists today. You have already seen my colleague, Advocate Samira bin Ali, Outreach and Engagement Coordinator, World's Youth for Climate Change, Climate Justice, and alongside I from the Bangladesh Society of International Law are chairing this session. We have as speaker Advocate Belinda Rukiminisina, Pacific Island Students Fighting Climate Change, Executive Secretary to the Trade Dispute Panel at the Ministry of Commerce, Industry, Labor, and Immigration, Solomon Islands. Next, we have Advocate Erika Lennon, Senior Attorney, Climate and Energy Program, Center of International Environmental Law. Next, we have Advocate Nicole Ponce, Global Advocacy Lead, World's Youth Justice for Climate Change. Then we have also from BSIL, Advocate MD Mustafa Hussain, Advisor Humanitarian and Refugee Law, Bangladesh Society of International Law, and Academic Coordinator and Assistant Professor, School of Law, Brak University, Bangladesh. And finally, we have our keynote speaker for the session, Dr. Mashur Salekin, another advisor of BSIL on environment and sustainability, and currently serving as the additional Metropolitan Session Judge, Dhaka, Bangladesh. So I'd like to hand over the floor to Advocate Belinda Rukiminisina. Over to you. Samira, can you please confirm if she is in the call?
I think that she is having connection problems.
Okay, then I think we can start with Erika, perhaps, in that case.
Maybe I could just go ahead and give a few grounding words on the key findings of the court that Belinda was supposed to present, and then we can hand it over to Erika, if that is okay.
Okay, then. Yeah.
Thank you so much. So just as a reminder, the UN General Assembly voted in 2023 the resolution to provide us with this advisory opinion, which was basically asking two core questions. The first one was on the obligations of states in regards to their obligation to protect the climate system, and the second one was on the legal consequences that stem from that, especially in regard to small and developing states, but also to future generations. Then the proceeding for that started. The court accepted to take on this request from the UN General Assembly back in April of 2023, and the states were given until March 2024 to provide their written statements In August 2024, the states were given also the opportunity to comment on each other's submissions. And finally, in December, from the 2nd until the 13th of 2024, states were invited to come to The Hague and present their oral arguments. And what we have also seen is that with the public hearings, there was also a lot of civil society activities going on at the same time, trying to make sure that the state know that this is a movement also by the people and for the people. As you already know, I think that Fahim has already explained it, but I always like to remind us of this date, but because it's such a consequential date for us working in environmental law, climate law, on July 2025, the 23rd of July, finally, the ICJ provided us with a historic advisory opinion. Not only historic because of the number of states that participated in proceedings and also international organization, but by the findings that it made. Those were findings that we have been working on as lawyer, as civil society, to be recognized in the international stage, and this was done. So first, the court recognized the importance of science, in particular, the best available science from the IPCC, particularly to its paragraph 74. This is such an important paragraph to ground us in the reality of climate change. And then they clarified the legal applicable framework also of this opinion. They made sure to explain that the Paris Agreement is not, and UNFCCC is not lex specialis. We must look beyond the climate treaties when we're talking about climate change. They made mention of the Convention of Biodiversity, Diversity, the Convention to Combat Desertification, International Covenant on Human Rights, Customary International Law. We were really hoping for this so that we can also talk about legal consequences. The state also made several really interesting clarification. They clarified that 1.5 is the legal norm the state have agreed upon, and this is the limit from which states must act to stay within in terms of greenhouse gas emission. We clarified that every state has an obligation to act with stringent due diligence to use all of the means at its disposal to prevent harm to the climate system and to protect human rights from climate impacts. They also mentioned the fact that, for example, the human right to a healthy environment is a precondition. A healthy environment is a precondition to all of our human rights. So this is a really big thing. They made mention of the NDCs, which is extremely useful for this particular COP we're in, because this is the NDC COP, which must reflect the highest ambitions of states, and they must become also more ambitious over time. And collectively, they must actually stay within the limits of 1.5 degree Celsius. State must also provide financial resources and assist developing states. States have obligation to mitigate, adapt, cooperate. They must have a duty to prevent significant harm to the environment. And they must also seize all wrongful acts if the one that was described before are happening. So there's quite a number of significant things that were described in this advisory opinion. It's quite a lengthy document, 140 pages. I invite you to go and read it. If not, please visit the World Youth for Climate Justice website, where we have made several analyses of it. So feel free to go and see that. Now that I've been able to ground us on that, I will let my colleague Erika Lenan take it over so that she can explain to us how this can apply in the next future.
Thanks so much, Samira, and thanks to you and the other organizers for inviting me to speak on this panel. I hope you can hear me well. I'm at the negotiations, and so and had to find a place to plug in, and so hopefully it won't get too loud around me, or the aircon won't do that. So as Samira explained, this is really a landmark decision for climate justice and really a potential game changer that can catalyze better actions and outcomes here at the UNFCCC and in the climate negotiations. You know, for too long, we've seen stalls in climate negotiations. We obviously are not, you know, it's been 30 years since the UNFCCC and all of the parties to the UNFCCC agreed to stop dangerous anthropogenic interference in the climate. And 10 years, it's been 10 years since the Paris Agreement when parties agreed to try and limit global warming to 1.5. And obviously, we're not there yet. And so, you know, that's one of the many reasons we turn to courts. And people turn to courts. And so really, as Samira explained, this advisory opinion lays clear what the law is and lays clear that parties have to do what they can to prevent significant harm to the climate, and that they need to respect the science, and that IPCC is best available science, and it is imperative and the law to keep global temperature rise below 1.5, and so everything needs to be aligned with that. And so really, you know, one of the things that we're doing and that negotiators should really do here is make sure that any outcome here is in line with the law and with the science. It's very clear. The ICJ has made clear what those things are. And so now that needs to translate. It's, you know, it's one thing to have it on the ICJ's website and on a piece of paper. And I, like Samira, would encourage you to read it. It's a fantastic read. Or maybe I'm just a sort of nerdy lawyer, but I think it's a quite interesting read. You know, we even have here one of the judges from the ICJ has been here at COP and talking about this ruling, but it really sort of sets out, you know, different guideposts for what can happen. So it focuses on, and it says what parties, it analyzes what parties' obligations are and what it means under the UNFCCC and the Paris Agreement, as well as, you know, that human rights, that customary international law, other multilateral environmental agreements play into it. But it also explained what states' obligations were related to the UNFCCC, the Kyoto Protocol, and the Paris Agreement, which is part of the role of the ICJ. And this is just to be crystal clear, this is binding law. So while it is an advisory opinion, it is the court's interpretation of binding international law, and this is binding on the parties. And so it can be used sort of across a whole host of negotiations here. One is making sure that the decisions taken are in line with the science. And I think too often we see decisions made that are unambitious or that don't put us on the path to keep warming below 1.5. And so, you know, it should be used here in, you know, whether that's the mitigation work program or advocacy for policy on the just transition work program, and to make sure that those outcomes are in line with what the court said. And one of the things the court pointed out was that failing to take actions to protect the climate system from fossil fuel production, consumption, licensing, and subsidies could be an internationally wrongful act and an illicit act for which states can be held accountable. And so if you're looking at what a just transition work program should do or what a mitigation work program should do, it should phase out fossil fuels. There should be a path towards phasing out fossil fuels. And that hasn't happened yet. And that also hasn't happened in the vast majority of the NDCs that were submitted. And the court, as Samira already pointed out, was very clear on what NDCs should do. And not only were not as many NDCs submitted as need to be, as all parties should have submitted them, they didn't include language around phasing out. They're not necessarily in line with 1.5 or with this advisory opinion, and so should, frankly, be redone. And parties should commit to that, and ideally they would call for that here. The court was also very clear on the duty to cooperate, both under the UN climate framework, but also customary international law. And a big part of this is, it is not only finance, but a big part of it is finance. And, you know, last year there was a very disappointing decision on what the new collective quantified goal would be. And so, you know, this can be used here to say, no, we really need finance. It's part of your duties. If you're not providing finance at a level and a scale capable of meeting the goals of the Paris Agreement, which includes both the temperature goal, but also making sure that countries are able to adapt in a way that enhances resilience, then it's not in line with your international legal obligations, which, you know, bolsters calls for more adaptation finance, for more climate finance generally. The language on subsidies can bolster calls for the outcome on Article 2.1c to really phase out fossil fuels. And so there's a whole host of things that can happen in these negotiations, including looking at and so parties really can take this and use it in those work streams. And we've heard some of that here. We've heard, you know, both ILAC, the Association of Latin American Countries, and the Association of Small Island States have both referenced the ICJ advisory opinion, as well as sometimes the Inter-American Court of Human Rights advisory opinion, because we've had 3 advisory opinions so far, and we'll have one upcoming. But they've used it and referenced it in various work streams. It is getting some pushback, particularly around the science and from those who deny the science or don't want to abide by this. But I also think it's really powerful that this advisory opinion was asked for by consensus by the UN General Assembly. So no party objected to it. Many of the countries that participate, we had, you know, close to 100 or around 100 countries and international organizations participating, including many of the big polluters. And so they all accepted that the ICJ was going to do this, and now they need to apply it. And you can't walk into these negotiation halls and say this no longer applies. It doesn't make sense to sort of pretend like international law, human rights law, customary international law doesn't apply once you walk into negotiating halls. It's still part of the thing. And so, you know, I think that it's really, I think the other part of one of the other key parts of the advisory opinion that is helpful and that relates to the negotiations is that the ICJ looked at a whole host of relevant conduct and sort of said parties need, you know, it's not just direct activities that directly emit greenhouse gases that is relevant conduct. It's regulation, it's laws. And so part of that is also, you know, frankly, would be the international laws and how parties show up here. And so I think, you know, the duty to make sure you're acting in good faith and acting across the board and in line with your international obligations means that you should be taking this into account here at COP and in the outcomes here. And that really, you know, I think that one of the things that the ICJ confirmed here is what many climate justice advocates, including, you know, many, you know, obviously from small islands and others, have been saying for years. 1.5 is the law. We need to take this action. States have an obligation to take action on mitigation and adaptation and to keep temperature rise below 1.5. And developed countries have to provide finance. And the court affirmed all of that. And so now this advisory opinion can really be used to strengthen and to bolster and to back up what many of those negotiators have been saying, because they were right. And so pointing out that the world's highest court has said this is I think really important. And then just the last thing I'll say is that obviously one of the, you know, part of the focus and one of the key questions that the ICJ was asked was on what happens if there's a breach of these obligations. And the ICJ confirmed that states have a responsibility to remedy harm that they have caused through breach of their legal obligations. And we know from the IPCC, which the court affirmed as best available science, that loss and damage from climate change will escalate with every degree of global warming. And there are numerous approaches to remedying loss and damage, including some here through, right now there's negotiations around the review of the Warsaw International Mechanism and the Fund for Response, and giving guidance to the Fund for Responding to Loss and Damage. And these mechanisms don't address liability or compensation, and responsibility for loss and damage from breaches under climate treaties is determined by, applying well-established rules on state responsibility. But that ruling and saying that states who are responsible have to remedy the harm should also bolster the outcomes on loss and damage here, and point out, and in particular, the need and the provision of finance, because the loss and damage fund is undercapitalized so far. And I probably have gone on for as long as I was supposed to, but I think that it's really important to take what courts have said and to put them into action. And this is one of the first tests for that. And I think that the momentum will only grow from here. But there are many things that we can do over the next 7 days or so, 8 days, that are weeks that's, I think, left till the end of COP, to really make sure that the outcomes here reflect in and reflect what the law is and what the science says. Thank you.
Thank you, Erica, for clearly taking us through the impact on climate negotiations and policy agendas. I'd now like to request Advocate Nicole Ponce, Global Advocacy Leads World's Youth Justice for Climate Change, to discuss on civil society and youth. Thank you.
Yeah, thank you very much. Thank you very much, Fahim, and Erica did an excellent explanation of the work that we're doing on the ground for COP. And Samira, I believe mentioned already that we also developed a pocket guide for negotiators and allies, and that's basically what Erica was explaining earlier on. And you can access these resources, I think, on the chat I've shared, and you can find them on our website, and of course in CL's website as well. If you need these resources, they're available. So I guess I'd like to start with that, because as civil society, it's important to highlight our role in this. As Fahim, as you mentioned earlier, I think earlier on, I think that resonated with me a lot, because the discussions we're having right now is that, what we're hearing is that people, especially from high polluting states, is that they're saying that the advisory opinion is non-binding, and they're really holding on to that to shield themselves from accountability. But these are not, as Erica mentioned, these are not new laws, and these are already existing binding obligations. And it's also up to us as civil society, as lawyers, as part of the academia, students, as young people, to make sure that this message gets across in negotiation rooms, in parliaments or in the government, to make sure that our officials, our states don't forget about this. And on the civil society side, we've also prepared, that's actually one of the things right after the advisory opinion came out, the implementation pathways that we've identified. For one, there's already, Vanuatu is already preparing a UN General Resolution and has announced that they're building a political power and momentum for a resolution to endorse these 3 advisory opinions, that one, not just the advisory opinion from the ICJ, but the ITLOS Inter-American Court. So in this upcoming UN General Assembly, for now, we don't have the actual resolution, but we would need broad country support for this one. And yes, we'll share details later on how civil society organizations can support on this. And we'll gladly share this widely as soon as this is out and we'll know better. And also, right after the decision came out, we've also worked with parliamentarians to draft parliamentary questions in order to initiate government responses to the AO. So parliamentarians can ask everyone here, you can probably reach out to your parliamentarians and ask questions to governments, either in parliament or in writing. And this can be done by anyone, by individuals or political parties. These questions will, in most democratic legislators, be addressed in the relevant ministers presiding over ministries dealing with issues to address what we're talking about right now, climate change and human rights. So this will be very important, and I guess also an important avenue to explore civil society organizations, and a very, I would say, concrete way on how we can make sure that the advisory opinion gets into these into Parliament, in this, or in Congress, or in Senate hearings. And civil society has organization has a huge role in making sure that we're able to make that possible. And there's also another one. We can also write, everyone here, you can write to send out letters to your ministers, to your ministries on Climate Change Commission or human rights or the environment. And I'd like to share how this particular implementation pathway is very important, because not a lot of people know, but before we got to the ICJ, we had to go through the UN General Assembly, and a very important or crucial way to reach out to our country, our state officials, was actually writing letters to our ministries. So young people from different parts of the world wrote to their ministries. In fact, many of them handed out their letters in person, went to their ministries and gave out this letter asking their countries to support the UNJ resolution. So yeah, let's not underestimate, just want to emphasize, not to underestimate the power of writing to our officials and perhaps bombarding them with this request to acknowledge the advisory opinion and how it can be really useful. And then, as Erica mentioned, especially for those at COPs, or even if you're not in person in Belém, but reach out to your UNFCCC delegation and help them integrate these findings. And we have the pocket guide for that, and it extracted the relevant texts from the AO into different work streams. So whichever agenda you're following, whichever track you're following, there's a provision that the ICJ really gave us a lot in this advisory opinion, which would be useful in just transition, loss and damage, human rights, the adaptation, finance, and you can find that and hopefully reach out to your UNFCCC delegation and make sure that they integrate this, especially into this the ongoing negotiations. And also really important is the NDC advocacy. So the advisory opinion was especially strong on nationally determined contribution. And while this is all very important, I think it would resonate to a lot that the building blocks really of making sure the advisory opinion is becomes an authoritative reference is really on a regional and domestic context. So NDC's advocacy is crucial to that. And I hope that, again, when speaking to your governments or state officials, that this gets emphasized and the strong language of the advisory opinion surrounding NDCs. And finally, also, things that we've explored, we've established like a green legal lab all around the world. So hopefully incorporate in curriculum, in law and policy courses, the different advisory opinions. So we have professors right here or part of the academia. That might be something you'd be interested to Bart and to include in your curriculum, and to make sure that it's really it really becomes the authoritative reference, and it becomes part of our legal arsenal as civil society organizations to make sure that that it's translated and integrated into regional and domestic contexts. I think I'll end with that. Happy to later on take questions.
Thank you, Nicole, for wonderfully touching the topic. Particularly, I think the pocket guide has been a very useful resource for the people to have good understanding of the advocacy level going on. On that note, I'd like to invite Advocate MD Mustafa Hussain, Assistant Professor, School of Law, Brack University, to discuss on the regional perspectives and applicability.
Okay, I believe I am audible and I can be seen, right? So, thank you very much for organizing this particular event. I congratulate Bangladesh Society of International Law, being the pretty young but adventuring to such kind of global level event, which will make Bangladesh relevant in the global advocacy and campaign for the climate change cause. Absolutely, no doubt to echo differently with whatever the previous speakers have mentioned. 23rd July this year is remarkably important for countries like us. From my personal experience, I frequently I publish in the Yearbook of Environmental Law on the reports of Bangladesh. I had a couple of publications, and well, every year when I review the performance and then the practice of Bangladesh as a state before international forums and in any other venues, one of the thing very common is that and as a country which is vulnerable to the climate change, the question of loss and damage, the question of technology transfer, and the question of how to continue with sustainable development and how to mitigate the climate change challenges. Now, there were not much substance for countries like Bangladesh, many countries in Asia, Africa, and Latin America to build their case strongly in the international forum. And we all know that international law has certain features, and one of its limitation feature is the aspect of enforcement, is the aspect of its implementation. Now, from that point of view, as a researcher in international law, I find the ICJ judgment a remarkable one, which for two reasons. Number one, the judgment, although not binding as an advisory opinion, but nonetheless, uh, within its attempt to, engulf the whole climate change and state responsibility perspective, it tried to, encapsulate from different and from all surrounding aspects. For example, while starting with the three key instruments, the court unanimously agreeing that obligations under Paris Agreements, Kyoto Protocol, and UNFCCC creates, of course, legal obligations. The court extended and went beyond this and declaring that under customary international law, the states will have the obligation, and that really matters because the conception was that climate treaties are flexible, non-compliant. Now the International Court of Justice declaring under customary international law obligation of due diligence is created in the context of climate change. It really matters, and seriously it creates impact. And secondly, if you look into it, it extended to other environment related instruments like CBD, then Montreal Protocol, and Desertification Convention. While not stopping there, the court finally looked into the human rights approach. And that is where, from a very individualistic point of view, the court vehemently declared that, okay, individuals have obligation under human rights. The states have obligations under human rights to protect the environment. And this is what the climate system is related to. Therefore, in terms of the interpretation and explanations from the court's point of view, the judgment have made a comprehensive interpretations and package in international environmental law. It strengthened the environmental law. It contributed in changing the nature of this climate change whole regime. Now, moving ahead with the question of compensation, question of reparations, question of about attribution, I think the court made a wise and forcing decision by also touching upon the issues of reparations and compensation thing. because that is where the struggle lies. Now, as we all know that the relevance of this state responsibility related articles are much more in the context of climate now. It will give advantages to countries like developing countries and least developed countries, small island nations, to better strong their cases. And as the previous speakers have also mentioned, that engagement of different forums, diverse communities, activists, and all us stakeholders, I'm sure that this judgment will lead in the future course of direction in the interpretation of laws and in making the climate related issues stronger. Now, of course, in our global forum, countries in the developing as well as in the global south will have a strong voice, number one. Number two, they will pursue better in terms of the financial and technology transfer issues. They can, in their domestic incorporation, they can look into the ICJ interpretation. And of course, when the human rights law, when the human rights is connected, the fundamental rights within the constitutional aspects are also, enshrined. So states can find, states have now, states have the option of, looking into these aspects. The only point which I would like to emphasize here is that uh, in spite of its being an advisory opinion, and sometimes we see that this kind of judgments impact in the global legal order, particularly in the developments of the scholarships. Like one dissenting opinion of Judge Tanaka in the Southwest Africa case regarding the UDHR has, in the academic world, really impacted, followed by advisory opinions on nuclear issues, and that really helped. Judge Viramantra's approach again really made remarkable approach and diversity in the scholarships in academia. As per Article 38 of the ICJ statute, when we look into the international laws framework, I find this judgment a whole package of and for the developing and LDCs who have been looking for some legal basis, and their voices are echoed basically with these judgments. And one of the important aspect I forgot to mention, that while in the making of their submissions, I was reading the submissions of these nations. I mean, it's so strong, like these nations have tried their level best to make their case before the court, knowing that it will be an advisory, but nonetheless they believed in it, and the result is as we see. So there will be several challenges, I believe, that in the enforcement issue, and of course in resource constraints of these nations, including the expertise and other engagements. I believe with the strong advocacy and the way this program is stratified, such kind of more engagements will certainly help to minimize the gap of north and south, as well as to develop a better coordinated approach in the long run. So thank you very much. I'll stop here.
Thank you, sir, for your wonderful remarks. Now, I'd like to invite our session's keynote speaker, Dr. Mashrur Salekim, Additional Metropolitan Session Judge, Dhaka. I have been aware that you have a meeting to attend, so I'll leave it to your discretion to the extent you can make it for us. Thank you very much.
Thank you, Fahim. Am I clearly audible? Thank you, and good to see Erika, Mustafa, Fahim, Nicole, Mahuba, all familiar faces. And I mean, it's really a proud moment for me to be here, because this is something which we have been looking for, that the advisory opinion, and we are discussing on that. I mean, looking into the enforcement issues, and as Mustafa has been saying, that there are a few challenges maybe, but I think we need to work out the challenges, and we will be successful, I hope. So I extend my gratitude to the organizers, particularly World Youth for Climate Justice, Pacific Island Students Fighting Climate Change, and my colleagues from BSIL, who have been instrumental in organizing this wonderful event today. So while we are looking at this advisory opinion, so over the last few years, something very remarkable has happened in international law. So advisory opinions from ITLOS, the Inter-American Court of Human Rights, and most recently this ICJ opinion have together reshaped how we understand state responsibility in the climate era. So across all three institutions, the message is very clear and unified. That climate inaction is not simply irresponsible. It is a breach of legal duty. So these bodies affirm that environmental protection is not optional, not merely policy-driven, and not something states can delay for convenience. It is now firmly recognized as a human rights obligation, grounded in principles of dignity, equity, and intergenerational justice. And this marks a profound shift. We are moving from a world of voluntary pledges and political promises to one rooted in binding principles of justice. International law is telling us that climate action is no longer a choice, it's an obligation. But as we all know, legal principles only matter when they are implemented. Advisory opinions, no matter how powerful, cannot change realities unless they are translated into laws, judgments, and accountability mechanisms. So from my point of view, there are three key pathways that can make this translation possible. So initially, the national courts can play a very vital role here. I, being a judge, I believe that the courts can take the lead in enforcing this sort of rights. And as has been we've seen that the Supreme Court of Bangladesh, the Supreme Court of India, the Court of Pakistan, they have recognized the right to life. And there are many other countries who have done the same thing. So the courts can take this lead here. Secondly, we need translational collaboration where the courts, legal institutions, and scholars across regions can build a shared body of climate jurisprudence. When similar judgments emerge across Asia, Africa, Latin America, and the Pacific, they generate a normative force that even the most reluctant government cannot ignore, I believe. And thirdly, public interest cases supported by communities and civil society can compel governments and corporations to comply with the obligations. Litigations can drive systematic change, not by punishing states, but by guiding them towards responsibility, fairness, and transparency. And I believe the Agenda case shows us the way, but the Global South must not lag behind. At its core, the climate change is not only an environmental crisis, it's a human crisis. In Bangladesh, where I belong from, this truth is felt every day. Rising seas swallow homes, floods take away livelihoods. Salinity intrudes into farmlands and drinking water. Thousands are displaced each year, not by conflict or politics, but by the slow violence of changing climate. These people are not mere data points. They are families whose rights to home, to security, to dignity are being eroded. Climate litigation must therefore do more than protect ecosystems. It must protect people. Accountability must match the human cost of climate impacts. Those who suffer the most must not be left to bear the burden alone. So here, the role of the judiciary and legal practitioners are very vital, as I was saying earlier. So we must see ourselves as the guardians of planetary integrity. Courts already have powerful tools at their disposal. They can require governments to report transparently on their emissions and actions. They can ensure that adaptation funds reach those who need them most. They can hold corporations to strict standards of environmental due diligence. And they can affirm that environmental harm is as serious as any other human rights violation. But to do this effectively, the legal community must work across disciplines. Climate litigations today require science, economics, human rights law, and community knowledge to come together. The law must listen to evidence, but it must also listen to people. So we must try to empower people through law. Institutions alone cannot deliver climate accountability. True accountability comes from empowered people. So grassroots movements, youth activists like you people, frontline communities have already reshaped global climate discourse. Their voices propelled many of the advisory opinion processes we are now discussing. So we need to call for a new legal ethics. We must move from declarations to enforcement, from promises to protection, and from climate policy to climate justice. In this era of unprecedented ecological change, accountability must guide governance. Climate duties must be understood not only legally, but ethically, as responsibilities to each others and to future generations. So I would like to close with a simple truth drawn from years on the bench, that law finds its meaning not in what it declares, but in what it delivers. So let COP30 be remembered as the moment when the law gained moral clarity, courts gave international principles life, and collective resolves gave them lasting power. Thank you, everyone. If there's any further questions, I would be happy to respond to this.
Thank you very much, Dr. Marsha Salekin, sir. With this, I think we are at the end of at least our discussion part at the session, and now maybe we'll be going forward to a question. Before that, I'd like to ask if our discussant, Mahbooba Kamal, Shaping Scholar LLM in Human Rights University of Birmingham, has any guiding question where we can direct. Thank you.
Thank you so much, Abid, for giving me the floor. Thank you so much for this insightful and timely session, along by our excellent discussion given by our esteemed speakers. Based on the discussion, I am actually concerned about the regulation of the private actors mentioned by Dr. Mashu Salekin, sir. So since the ICC advisory opinion established that the courts have a due diligence obligation to prevent significant harm to the climate system, and that this obligation extends to regulating the activities of the private actors like the multinational corporation within their jurisdiction or control, including in sectors like fossil fuels productions. So besides that, the court also affirms that the climate change hinders the enjoyment of various human rights, including right to life, health, and clean environment. So given this clear linkage between the climate due diligence and the regulation of private actors, how do our respected panelists foresee this ruling immediately impacting domestic and regional efforts to introduce a mandatory human rights and environmental due diligence legislation? So more specifically, what mechanism should the human rights defenders focus on at the domestic or regional level to ensure this regulation actually has been implemented by the state? Thank you so much.
Thank you, Mahbooba. I'd like to ask if any of our panelists would like to take that question. Erika or Nicolaya?
I can give it a go, but very happy to hear Nicole's answer as well. I mean, I think that yes, the advisory opinion I think was also clear that states have a duty to regulate corporations, and I do think that this advisory opinion really does put the fossil fuel industry and other big polluters on notice that they have to phase out and they have to stop their harmful activity. And I think similar things are true, and I do think there's similar things about the regulation of corporations in the Inter-American Court's advisory opinion. And as for what the best path is for environmental and human rights defenders and what they should focus on, I don't know. And I think that that's probably very context specific and very specific based on country and region that you're in, because what may work for sort of changing legislation or doing something in Brazil may not be the same as would work for changing legislation in India or Malawi, or I'm just choosing countries at random here. And so I think it really depends, but I do think that there are avenues and that the advisory opinion lends support to those who are looking to change regulation, those who are looking to enforce, making sure that there's stringent due diligence related to preventing harm to the environment and human rights, gives strength to domestic court cases. I think it also gives strength to regional cases, as does, if you're in the Americas, the Inter-American Court's advisory opinion on climate change combined with the ICJ's, I think really gives a lot of credence to bringing potential cases there, for example. And so I think it really think it's up to the, it's up to the communities, it's up to the defenders to decide the best path for them. But I think this opinion is a tool, much like the reports from the IPCC are a tool that everyone can use. The IPCC says what the best available science is, and the ICJ advisory opinion basically explains, for lack of a better way, the best available law, or what the state of the law is. And so it can be used as a tool by governments, by negotiators, but also by environment and human rights defenders at all levels to bolster their arguments.
Right. Thank you very much, Erika. I mean, yes, we have already seen the advisory opinion being into the actions. In Korea, there have been like 6 farmers who filed a case against the state invoking the advisory opinion. You have also seen this in Canada, the court interpreting this. Also recently in Brazil in a coal factory case. So it's already been action and we see a great progress. Yeah, Samira, maybe you wanted to say something?
Yes, I just wanted to add into actually what you started, that we're seeing actually this advisory opinion is already being used, and because it went so far into including human rights, and it made mentions of human right to life, to water and sanitation, to right to livelihood. I think that this is really opening what we have already seen, this tendency of taking human rights to protect us from climate harm. As you, Fahim, you gave so many other examples, but I want to continue on that path that you started and give other example again to show how this is already starting to be used. We are seeing a case in South Africa where South Africans environmental groups have relied on the ICGO finding to challenge a shell plan for new oil. We're seeing that there is a case that was started by Greenpeace Nordic, this is Norway, to also stop oil gas projects from progressing. We have also said that the Children's Trust have had started a petition where they use also in the US the advisory opinion. We're also seeing that in a not really outside of the court, also states that are progressive are also starting to use it in their NDCs. Bangladesh is one actually who was starting to use it. Vanuatu is another also that has used it, and they are trying to give a blueprint of how that could look like in the negotiation rooms for states. So actually, I think that we're seeing those creative movement lawyers and regulators and policymakers that are really trying to make sure that polluting states are, not doing what they want. So we are saying it. It's only been a few months. Can you imagine what it's going to be in 2 years? So yes, the advisory opinion is going to be in all of the different courtrooms and policymaking spaces.
Thank you, Samira, for the insight. I mean, yes, we were having a moot in my university, and then then this came up. So there was a question being asked, like, even if we consider that the parties gathering together before the International Court of Justice as the opinion juries, we are soon to see the state practice widespread. And we don't know, maybe soon we will see the International Law Commission declaring it as a customary international law, or maybe something. We are hopeful. Given the limited time we have, I'd like to, I was going through the questions we have. I also like to thank over 200 attendees who have been watching this session live. So 2 questions really caught my attention. I think that deserve the discussion. One is a part extended what already Erika discussed, but this is also a personal question I have been trying to research. Also, I see some of the people mention that if a multinational company or non-state or private actors have been invoked by the state for their non-compliance with the environmental rules and all, and as a result, as a consequence, if they think of withdraw, and if it's in a context of a country like Bangladesh or maybe some other country, and there is out of nowhere 10,000 unemployed people, they're withdrawing their establishment, how do ICJ actually take care of this, or how do they approach it? Also, another questions complementing with this, someone really asked in the chat box that whether the victims of climate change can go for loss, finance and damage, and is there any mechanism they can apply in the international fora? So if any of you would like to answer.
I didn't see anyone else raising their hand, so I'm going to jump in, but I definitely invite Nicole and Samira and everyone to answer as well. So on the first question, I think that one of the key things, and in fact, one of the key things being discussed in the negotiations here at COP30 is the Just Transition Work Program. And that we know that we need to phase out fossil fuels, and we know that like activities or like companies not going through with things can leave whole communities and the workforce, and that has impacts on families and everything behind. And so as we are transitioning and as we are moving to create, you know, a clean, healthy, and sustainable for present and future generations, we need to do so in line with justice and equity and principles of human rights. And so I think the emphasis of the advisory opinion on the relationship between human rights law and climate action and how it applies can really help in that and in making sure that as we're thinking through climate action, whether that's mitigation or adaptation, or you know, something related to loss and damage, that all of that action is being taken in line with respect for human rights, for labor rights, for respecting people's right to life and livelihood. And so it's important for countries and companies, frankly, to make sure they're not doing harm, whether it's by their activities and then, you know, paying or repairing the harm that is done, or whether it's, you know, ensuring this just transition. And I mean, we'll see what happens here, but that's definitely one of the key fights being discussed at COP30. And then just on the second question about remedy and reparations, you know, the ICJ was clear that states have an obligation to repair and to remedy harm, and that includes cessation, but it can and can include satisfaction, but also includes reparations and compensation, and it can be for both economic and non-economic loss and damage. The ICJ itself is obviously a court between states, but that doesn't mean that communities can't or people can't use potentially domestic courts or international or regional systems and human rights courts, use human rights treaty bodies or contact, you know, special procedures mandates. That doesn't necessarily get you to the remedy. And I think that also one of the things that is being fought for here in the fund for responding to loss and damage, one of the core asks has always been that there is a way for communities who are impacted by the climate crisis and suffering loss and damage to directly get financing and compensation for that. And it's a struggle, and I have a colleague who follows that more than I do, but I will just say that that's like one of the key asks from, you know, civil society and others has been to make sure that there's direct access to that financing as one form. But I'll stop because I feel like I'm answering all the questions.
Thank you very much. I perhaps will take a few more questions. Advocate Mustafa Hussain had to leave. He is with his mooting team in another country. So I could not really direct the questions to them. Also, Dr. Salekin had another meeting to attend, but I see he's still in the call. So the next question we have from Ghana, Awin from Ghana said, given the rise of the digital tools, GIS, drones, and remote sensing, how can international climate law frameworks incorporate technology-certified data to prevent states from underreporting emissions or climate impacts?
I see Erica here. I mean, that's a very difficult question, but I guess, well, for me anyway, but very relevant and very useful. I think we can use that. I'm sorry if I just jumped in. I think we can use that as a as part of our brainstorming activity, we often emphasize that the advisory opinions, both, I mean, all three of them, are quite unprecedented, and there's a lot of unpacks. So I didn't quite catch the name of the one who asked, but that's definitely something we can explore as civil society organizations, how we can start campaigns and advocacy surrounding that, because that's the thing. The AO's advisory opinions has given us so much, and it's very much a useful tool in many jurisdictions, in many advocacies. So the idea is to, again, use it as an authoritative reference. So if this is something that you feel that would be really helpful, then I suggest you reach out to different advocacy groups, or perhaps to your governments or about it, and use the ICJ as a reference for that. Let's see.
If I can maybe add into that, one thing that I found really interesting with the advisory opinion is that it make us use the best available science. That is really the grounding from which we start, and the best available science, thankfully, is becoming more and more accurate for the IPCCs and other scientific bodies, thanks to all of those technologies. And that best available science is particularly important when we talk about reparation, because it's going to help us, do that causation link. Because when we're talking about the effects of climate change, those are really diffuse. And when we go to the court, we must prove that this particular community, this particular state has been affected by climate change if we're suing another state because of this particular state's emissions. And being able to prove that, we need to use attribution science, which is a field of science, basically trying to demonstrate those links. And those new technologies, to me, are going to help us really support our climate international law frameworks to go there to get those objectives. And we're seeing them being used for many of the extreme weather events that, for example, I'm talking, for example, I'm from an island that's called Mayotte, and yet last year we faced a huge cyclone that destroyed a big part of the island. And due to attribution science and all of those new technology, we're able to showcase that this cyclone was really amplified by climate change. So I think that those are vital technologies to help us support our cases. And the ICG thankfully opened a door. It didn't go in depth, but it opened the door for us to use that.
Right. I would like to also briefly add, since I am presenting a paper titled Governing Remote Sensing and AI in Forest Management and International Law Framework exactly 7 days from now in a conference in Slovenia. I'd just like to add with very insightful information by Samira and Nicola that there is this United Nations remote sensing principles, and I am trying to couple this up with the discussion took place during the COP28. Where AI-enabled climate tools has given a huge discussion there. So yeah, I think these are the materials one can look into. Since we're at the very end, I think I'll just take one last question, and we'll be very briefly, maybe in a few minutes, we can finish this. So it's a big question. I don't know if you can see. Speaking from a deeply rooted climate hash experience in rural Nigeria, particularly in the Benue state, north central Nigeria, many climate laws and governance frameworks do not reach our communities, even though the impacts of climate change continue to worsen every now and then. In this context, how can the UN Special Rapporteur on the Human Rights to a Clean, Healthy and Sustainable Development ensure that the Nigerian government effectively implements climate laws in rural areas? What mechanisms or approaches can guarantee that these protections and policies truly reach marginalized communities who are their cases is empathetic? As we gather for COP30, this should be the moment to reshape a narrative pushing for climate localization and youth gender responsive breakthrough that place rural and underrepresented communities at the center of climate action. From Mr. Asaga, Founding Coordinator, Gender Equality Hub, Nigeria. Samira, would you like to answer, or maybe Nicole. Yep.
I can start to answer it. So the UN special procedures are interesting mechanism, especially for us in society, because they gave us an open door to access and showcase our grieving to the UN system, in particular the UN in Geneva with the Human Rights Council is a good way to do that. Just to tell you that the UN Special Rapporteur on the right to a healthy environment, they decide their agenda quite early on and which state they're going to visit. So the thing that I would recommend is that there is an address email where you can ask actually for the UN Special Rapporteur to come and visit your country and show them this is the environmental degradation that we're facing. And then if the UN Special Rapporteur accept that request, they will make a final report with a recommendation that they will present at the Human Rights Council in one of the meetings that happen every year. And otherwise, if that is not possible, the UN Special Procedure, they provide spaces for civil society to answer a question that they're asking about breaches of the law. If you go again, they do ask that on a regular basis because they provide again report to the UN and calling out say that when it's needed. And if that doesn't work, I think that the different human rights committees of the UN have been quite useful for communities that have been impacted by environmental and in climate harm in the past. I'm thinking, for example, right now of the Torres Strait Island case. Those islands that have went and sued the government of Australia in the Pacific so that they could prevent harm to some of their human rights that they invoke, such as the right to life, also right to healthy environment, and they also invoked some of their rights being affected from their traditions being disrupted due to climate change. So it is possible to go through those human rights mechanisms to make sure that your grievances are heard. I think, as you mentioned, again, COP30 is extremely important moment. As we're seeing right now, there is NDC gap report that has been published that showcase that states are still not ambitious enough. We're not in the pathway to stay between 1.5 degree, and we're going far beyond 2 degree if states implement what they have said in their NDCs. So indeed, we must provide a pathway for communities to be able to showcase their rights. Thank you. I don't know if someone else wants to add anything to that.
No, I think you have covered it really well. Thank you very much, Samira. And also, I think we don't have much time left, so I think we can draw the formal conclusion. Yes, Samira, over to you.
Yes, thank you so much, Fahim. This discussion has been extremely rich, and I'm so grateful and happy to have this conversation right now as the first COP where we have the advisory opinion, but also as a COP where we're realizing, as I was saying, that things are still not going in the way we want. I talked about the NDC gap reports, but there is also another report that was published recently, the tipping point report that is showcasing that we are reaching most of the tipping points on our natural environment and climate system. And those are showing us that we're not in the good pathway. But in the light of all of this environmental damages are happening or around us, those advisory opinions, not only the ICJ one, but also the Inter-American Court one that goes obviously even deeper in human rights aspect, but the ITLOS one also, and now the soon upcoming African Court advisory opinion are showcasing for us pathway for hope, and they're also showing that the law can be one of our recourse to provide justice to communities across the world. So thank you so much.
Hello, everyone. Thank you so much for this super insightful session. So as a moderator, I will conclude that this wrap up our session. So basically, we will now have our very short health break. And then as you can see in the chat that I also give the instructions. So the next session will start at 1 p.m. Brazilian time in approximately 30 minutes. And to join the next session throughout the day, please simply click on the relevant event Zoom link in the program that you will have received by email as chairs. And then at 1 p.m. Brazilian time, we will have our second set of session until 2:25 Brazilian time, which would include the legal experts and practitioner roundtable, and also a legal roundtable on advancing climate justice, and another one on educating climate dispute in a new era, and also finally one more on leveraging national legal frameworks for just transition. Yep, thank you very much, and we'll see you again soon.